capital, the American Enterprise Institute for Public Policy Research presents Public Policy Forums, a series of programs featuring the nation's top authorities, presenting their differing views on the vital issues which confront us. The topic, freedom of the press, the First Amendment protections. Should reporters be forced by the courts to reveal confidential sources of information? To what extent should the First Amendment protect the press from libel suits by private citizens? Now, here is Peter Hackus.
In this bicentennial era, as we re-examine some of the great principles on which this country is based, freedom of the press stands out as a cornerstone of our democracy. From time to time, that word freedom has to be spelled out in detail if the First Amendment to the Constitution is to have some specific meaning. Is the press free, for example, to print any item, even if it might damage the individual rights of a certain person? Is the press free not to print certain items because a government agency says it might be a threat to national security? And who decides these matters? The newspaper, the government, the court? Should a reporter be privileged, protected by a legal shield against being forced to reveal his news sources? Does the public have an absolute right to know? From the National Press Club in Washington, welcome to another roundtable discussion presented by the American Enterprise Institute, a nonprofit, nonpartisan research and education organization. Today's guests are well-versed in the topic, freedom of the press, the First Amendment protections. Members of our panel are Charles Seib, Associate Editor of the Washington Post. Mr. Seib has been a reporter or editor for the Associated Press, Gannett News Service, and the Washington Star. Floyd Abrams, a partner in a New York law firm which specializes in communications law. He has filed many briefs in First Amendment court cases. Antonin Scalia, an assistant U.S. Attorney General involved in press freedom cases. Mr. Scalia served as general counsel in the White House Office of Telecommunications and as chairman of the Administrative Conference. Edward Epstein, director of a research project on news agencies sponsored by the 20th Century Fund. He's author of the book, News from Nowhere. Jack Nelson is Washington bureau chief of the Los Angeles Times. He's a Pulitzer Prize winner for his investigative reporting while serving as a reporter for the Atlanta Constitution. Moderating our discussion is William Ruckleshaus. Mr. Ruckleshaus served as Deputy U.S. Attorney General and as head of the Civil Division of the Justice Department. He also headed the FBI and the Environmental Protection Agency. Mr. Ruckleshaus practices law in Washington, D.C. Now our moderator, Mr. Ruckleshaus.
Thank you, Mr. Hackus. The First Amendment to the United States Constitution states Congress shall make no law abridging freedom of the press. Through our history, the meaning of those words and the nature of the freedom it protects have caused controversy. Tonight we are going to discuss with our distinguished panel and later the audience three current controversies whose common theme involves the tension between the First Amendment and the government's exercise of power through the judicial system. Newsman's privilege. Should a reporter, under any circumstances, be forced by the courts to reveal their confidential sources of information? The Supreme Court in 1972, in the case of Brandsburg against Hayes, said under certain circumstances a newsman could be forced to testify before a grand jury and forced to disclose the identity of their confidential news sources. Since that time, and really before, several so-called shield laws have been introduced in Congress and in the states to protect the confidentiality of a newsman's source from judicial interference. Libel. To what extent does or should the First Amendment to the United States Constitution protect the press from libel actions by private citizens claiming they were wrong? Is there or should there be a difference between the protection provided a private citizen and a public figure? Lastly, to what extent should the courts prohibit the publication of classified material? Starting with the Pentagon Papers case and continuing with the current sensational revelations about our intelligence gathering agencies, are there any limits in the name of national security to what may be published? In no particular order, let's start with newsman's privilege. Mr. Nelson, let me ask you, should the Congress of the United States pass a shield law, absolutely protecting the rights of a newsman not to reveal his confidential news sources anywhere in the country?
Well, I think Congress should pass such a law, and I think it should be an absolute law, an unqualified law. I would be opposed to any sort of law that had qualifications and that might open such a bill to amendment in the future. And I'd like to just say, by way of background, I became a member of a group called the Reporters Committee for Freedom of the Press, which was formed after Earl Caldwell was subpoenaed, and the first case where the Justice Department began to subpoena reporters during the Nixon administration. This committee, formed of working reporters, mostly in Washington, saw that there was a necessity to protect reporters and their confidential sources in cases particularly where investigation of government is concerned. And the Reporters Committee has been in favor from the outset of an unqualified law. Now, I think, for example, that if the Nixon administration, for example, had been able to subpoena Woodward and Bernstein of the Post, other reporters, and learn confidential sources, you would have never had Watergate uncovered. And there are many other stories that you can look at that would have never come out had reporters been subpoenaed and had they been forced to divulge confidential sources.
Mr. Scalia, you're from the Department of Justice. Do you have a contrary view to that, or do you support Mr. Nelson?
Well, I think Mr. Nelson's view is the most rational, next to what I think is the correct one, and that is that there should not be a newsman's privilege law. The reason I say it's the most logical next to that is that there are many who think, well, we should have a newsman's privilege law, but it should be qualified, and that I think is the worst of both worlds. The problem is, if you have one that's unqualified, you just can't live with it, and if you have one that's qualified, it just doesn't work. So I think the best state of the law is the one that we now have, in which you cannot get a newsman to testify in court all the time. There are judicial protections against harassment. But on the other hand, there is no instance in which a newsman can go in and say categorically, the law gives me an absolute privilege not to appear. It really doesn't help the discussion to put the whole thing in the context of the Nixon administration subpoenaing newsmen. It normally isn't the Nixon administration. It's normally a court in a criminal case, and as often as not, they are subpoenaing the newsman not on behalf of the government, but on behalf of the defendant.
I would agree with you that you shouldn't necessarily put it just in the context of the Nixon administration, but you've got to realize that the subpoenaing of reporters did not begin, though, by the Justice Department until the Nixon administration.
No, I doubt very much whether that's true. I don't know all the facts on how many newsmen's subpoenas there have ever been in the history of American jurisprudence, but I find it difficult to imagine that a newsman had never been subpoenaed on behalf of either the government or the defense in any criminal trial prior to Nixon. At least I
can't give you a number, but we did come to look into it, and it was certainly our impression on reading every case we could find that prior to the Nixon administration there had been very, very few cases and very, very few subpoenas issuing, certainly out of the Department of Justice. There was a new, and to the press and I think the public, disastrous flow of subpoenas pouring out of the Department of Justice in the early days of the Nixon administration. That has stopped, certainly to a major extent. We do have, I'd like to add, a qualified privilege now in law, as a matter of law because of the cases that have developed. I tend to agree with Mr. Nelson that an absolute privilege would be a better idea, but I don't think really we should let pass the idea that a qualified privilege doesn't do any good. We do have one now. Case after case is coming down in court after court around the country, which is establishing that in situations in which there are alternative sources, for example, to get information, you can't go to the newsman first.
I don't
really need it very much, you can't go to the newsman first.
The Justice Department guidelines for subpoenaing newsmen provide exactly that, and I have no quarrel with that. If you're talking about a qualified privilege that is judicially created and administered, or one that is administratively created or administered, but I thought we were talking about legislation that would establish a qualified privilege in the sense that you don't judge it on a case-by-case basis, but you have some flat rule that will be applied in a certain category of cases. I don't think that achieves what the main purpose of the newsman's privilege law is intended to achieve, and that is to open up confidential sources and prevent the so-called chilling effect upon confidential sources, because
Mr. Seib has a remark.
I just wondered if this was a realistic discussion. Is there any possibility at all of getting an absolute privilege law out of Congress?
No, I doubt seriously that there isn't.
And once you
At
don't...
one time, there seemed to be a possibility.
Well, once you concede that you can't,
Once you,
wouldn't you rather stay with the First Amendment than get into
I would, and I think
limited...
You said you would too.
I said I would too. I have no quarrel with the fact that newsmen, for two reasons. One is that the freedom of the press is a particularly important freedom under our Constitution, and it has some special constitutional protection. And the second one is that newsmen are particularly subject to harassment by subpoenas, because they're in the business of finding out, investigating facts. Police departments could come to rely upon them to do their jobs. For both of those reasons, I think it makes sense to accord them some special protection through the courts and through the administrators, such as the Justice Department, not subpoenaing newsmen willy-nilly, which we don't do. But beyond that, I don't think any more is needed or is indeed desirable.
Mr. Epstein, what's your view on the privilege?
I don't really think that to clarify the issue and to try and pretend that there has been freedom of the press up to the Nixon administration, and somehow the Nixon administration violated this freedom of the press by subpoenaing reporters is historically accurate. I think you had complete censorship in World War II and the Korean War, where newspapers and magazines were told what to publish on the covers, what stories to publish, and they were threatened, editors were threatened by being drafted in the army unless they went along. You had the McCarthy period stretching into the early 50s, where newsmen certainly didn't have any sort of freedom to report what they wanted to. And while you might say that you could find very few cases of the government subpoenaing witnesses before the Nixon administration, perhaps they didn't have to, but certainly in private libel cases, hundreds of reporters were subpoenaed by one side or the other and made to divulge their sources. And you said to begin a discussion that newsmen have a right, and it's a question whether Congress should certify that right by a law, but the Supreme Court has never found that newsmen have a right not to testify if they're a witness to a crime. And the question really is it worth elevating newsmen to some special status by giving them absolute privilege, which neither doctors nor lawyers have? And Mr. Nelson says Watergate would never have been revealed if newsmen could have been subpoenaed. Well, I remember that Mr. Nelson, I think, had the single most important revelation on Watergate as far as the public was concerned when he published an interview with an ex-FBI agent, Alfred Baldwin, which detailed the entire Watergate crime as seen from the man who was the intermediary between the Watergate burglars and the conspirators Hunt and Liddy. And you published this entire interview, and if you had been subpoenaed, by the way, your editors were, but let's just say you had, and you went to court and you revealed that Baldwin was your source, I can't see that it would have made any difference.
Well, now, this is a little different story, though. Everybody knew Baldwin was the source. Right. The point here was whether or not the tape of the interview should be turned over because the interview had been conducted in confidence. And I think a good point here is, though...
But they were turned over.
Well, I know, but the point here is... Yeah, but Baldwin wanted them turned over. But let me tell you, though, I think that's a very interesting point. We operated in an atmosphere there of an intimidation of the government of the news media. For example, Ron Ostro of the LA Times, who was with me on that case, the two of us knew, in our own minds, that the government would try to get a hold of these tapes of the Baldwin interview. We felt sure they would. So when we came back to Washington, we sent the tapes to Los Angeles, and just in order to keep the government from getting them. Now, what happened immediately thereafter was that Earl J. Silbert, who was the original prosecutor of the Watergate case, did tell me that, they were going to subpoena the tapes. He said, what'd you do with the tapes? And I said, well, I can't tell you. You'll have to talk to our attorneys. And he said, well, we're going to subpoena those tapes, and if we don't, the defense will. Well, what happened was that the defense did subpoena them, and the Justice Department, in the person of Earl Silbert, stood up in court and said, we have no objection to the subpoenaing of the tapes, and as a matter of fact, we want to see them too. And that's exactly my point. There is intimidation, I think, of the media when the Justice Department is involved in subpoenaing a reporter.
But let's say hypothetically that this that aside from everything else, this witness, Alfred Baldwin, had already testified to the grand jury, had told them the entire story he told you. So even if you had been intimidated to the point that you couldn't publish your story, still the grand jury had heard the story and they would have brought it out in the trial.
Well, no, that's not exactly right. Let's put it this way. In the process of investigative reporting, this was an interview that went on over 2 nights. In the process, we learned a lot of things in that interview that did not go in Baldwin's story. It was the first-person story by Baldwin. It didn't go in because there were things that he could not substantiate. We wanted to use these things for investigative leads. You know what happened? We sent the tapes to Los Angeles because the editors asked us to do that because we were afraid the government were going to get them, and we never did get access to those tapes again, and we have yet to have access to those tapes. And there was material on there that would have been helpful to us at that time in investigating Watergate.
It was not the government which ultimately subpoenaed them, though, was it? It was the defense in the case.
Well, it was the defense that subpoenaed them, but it was the government, though, who said that they're going to subpoena them. And the government said, if we don't subpoena them, the defense will. And it was the government who stood up in court and said, this may raise the First Amendment question, but even if it does, the government has no objection to it.
I'd like to come back to something Mr. Epstein said earlier about how everyone has to testify to a crime that he's seen, and that is certainly a true statement of law. I don't think anyone that is advocating a newsman's privilege is really advocating, except in one particular type case, which I could touch on, that there should be any exemption of newsmen from testifying about crimes which they saw.
But isn't that what
people
Mr.
are talking
Nelson
about
says when he means absolute privilege?
No, he doesn't.
Mr.
Nelson's talking about interviewing people.
You ever heard of a case? I mean, you know, this is always raised an argument. I've never heard of a case.
This was Caldwell, I thought.
Most of the Justice Department subpoenas involve 2 types of situations. One of which is the exact witnessing of the crime. Television news films of the shooting of George Wallace, for example. And this, by the way, is one reason I think the number of government subpoenas to newsmen has increased in recent years, because of television, because of on-the-spot coverage of events at which unlawful action occurs or is charged to occur, such as demonstrations, Wounded Knee, and so forth and so on. These are actual films of the alleged offense. Now, either the government, which is trying to prove the offense, or even more so, the defendant, who's trying to demonstrate that he didn't do what he's charged with, it seems to me, has an overpowering right to have that thing shown to the grand jury and to the jury if it goes
I
to
think
trial.
that may be so in some cases. I think the problem with that, I mean, ABC newsmen were stoned in New York City when a time came in the late 60s when they were being thought of as being police agents and adjuncts of the New York City police force because they were being so routinely subpoenaed. The standard crime situation, which I think there is justification for non-testimony, is the Brandsburg case itself, where a reporter goes out, investigates, finds out that hashish is being made in Louisville, Kentucky, reports on the story which could not have been made known to the public absent a pledge of confidentiality, and then is subpoenaed to testify, has to leave the state finally, else he will wind up in jail. And I think the public is ill-served by that kind of law.
That is not the typical case, and I don't think that any discussion of absolute newsman's privilege should center either about solely the government's desire to get the film or whatever it is, nor should it center solely upon the confidential source cases, which are the most appealing from the standpoint of the newsman. Most of them do not involve confidential sources. The other most common category, besides news films of events, is the mailing of tapes and kidnap letters and such things to newspapers or television news stations or radio stations after a kidnapping, ransom notes, or such and such a building is going to be blown up. Now, on occasion, these have been denied when the police wanted the note for the purpose of trying to detect from it where the individuals concerned happen to be located. I see no reason for the extension of a privilege in such cases. There's no confidentiality involved whatever, and ordinarily there isn't.
Have you ever been chilled by a government subpoena, Mr. Seib?
No, never. When I was managing editor at the Star, we had the Agnew incident where there was some effort to get our reporters' notes, and that died. I haven't, but I was wondering, we talk about the increase in the number of subpoenas and efforts to, legal efforts to get material from the press. Is any of that due to the a sort of separation between the press and the authorities and the government, that things that used to be done cooperatively between the press and the authorities as now, as the arm's length distance between the two has widened, and we're more conscious of the need for separation. Is that one of the factors here? And
you gentlemen would know better than I.
I wouldn't think so. I mean, it may be a minor factor, but I wouldn't think so. I mean, for example, newspaper reporters are cooperating all the time in cases involving congressional investigations, in cases involving Justice Department or police investigations. It's not unusual for reporters to learn of some information that has to do with a crime and to cooperate with law enforcement officers. That's the reason I think that the argument about whether a reporter will testify if he witnessed a crime, I don't know of any cases where reporters really witnessed crime, unless, as you say, in the case where they went out and asked somebody to let them see them make hashish so that they could do a documentary on it, in which case nobody would have known of the crime anyway. You raised the case when you were testifying, for example, a hypothetical situation on the Hill about the Shield law, and you said that there could be a situation now, if you had an absolute Shield law, where a television station could have an interview with Patty Hearst, and then the Justice Department or other law enforcement officials would be unable to compel the television station to say where they got Patty Hearst and so forth. Well, the point is that you would know a hell of a lot more about Patty Hearst at that stage than you did before if they didn't have the interview. And had Patty Hearst known that this television station would tell the Justice Department or anybody else where she was, she would have never shown up for the interview. And this happens all the time.
The point I was making at that point in my testimony was a quite different point from the one we had just been discussing. I think that situation could occur if you had an absolute Shield law. And the main reason I think that situation would be bad is how seriously does a society really take the battle against crime if it could allow something like this to happen? You know, I don't know where Patty Hearst is on the FBI's most wanted list, but let's assume she's number one. And there she is, big as life on the screen in living color, and you know, a news reporter having an interview with her. I just don't think a society can take its law enforcement efforts seriously if it can allow something like that to occur.
Well, we've done that in 24 states where we have privilege laws, many of which are absolute. In New York, for example, if that interview did occur with Patty Hearst, the New York state authorities could not require a newsman to disclose the source of that.
Scalia is saying he doesn't agree with those.
I am sad for New York.
I think I understand that, but no. What I'm saying is that the country hasn't exactly collapsed either. New York is not precisely the best example of the best functioning state. But we do have these statutes around the country. We've seen no examples that I can cite or that have been cited in testimony that I've read.
Well, maybe New York doesn't have Patty Hearst. I don't know. I think the Patty Hearst thing would happen. If Patty Hearst would offer it, there is somebody who would snap it up like that, and I think that something like that would just have an enormously corrosive effect upon not just law enforcement, but the entire society's respect for law.
Wouldn't the FBI and the Justice Department know a lot more about Patty Hearst if they saw her interviewed on television than they know right now?
No,
I mean, they know very little.
No, not necessarily. I guess they'd have a current photograph of her. That might be helpful.
Might be.
But she might be disguised.
yeah,
You're seriously asserting that this would be a help to law enforcement efforts?
Well, I don't know, but I'm not saying it wouldn't be a hindrance.
I would seriously assert that it's a help to the public to be able to watch an interview with Patty Hearst rather than not. And the effect of what you're saying is that in the future, at least, you couldn't.
And what if it was Jack the Ripper? Would that make any difference? I mean, here's Jack the Ripper in living color. You know, hi out there, I'm interviewing television. I know the police can't get this film and they can't know where I'm being interviewed because the laws we live under say it's more important to watch me than it is to catch me.
Jack, I don't know.
Suppose it was Adolf Hitler when he was alive.
Mr. Epstein has a...
Jack, when you said witness a crime, that you would be for a witness being compelled to testify if he witnessed a crime, what would happen if you interviewed someone, or another reporter you respected interviewed someone, who said in the course of the interview or inferred that he might assassinate the president? And this came out in the interview.
Well, I mean,
let me just finish.
Obviously, I'd go directly to the authorities.
No, but let's say this came out in the interview. You put it in your story, and then your notes would testify to see if they could build a case against the person who said this. Would you submit your notes? Would you testify to the portions of the interview that you didn't? Because this was the Caldwell case.
No, how's that the Caldwell case?
Not quite.
That's not the Caldwell case at all.
Well, let's not argue about this, but take his hypothetical. What would you?
Well, I'd go directly to the authorities. I don't think I would need to if somebody told me they were getting ready to assassinate the president or anybody else.
Then what happens if
and see, that's the reason I say this is a false issue. I don't think any reporter who's a human being would listen to someone threaten, say they were going to kill someone else, no matter who it is, and not take action.
What happens then if the government subpoenaed your number?
I define anybody who's gathering the news for public consumption. And that's the reason I think the unqualified shield law would not just apply to me, but it would apply to anybody who went down to City Hall, got information from a confidential source, came out and distributed. I think they ought to be.
I think we have to decide which examples are more real, and I really think that a good part of the resolution of these things has got to go on that. You do have a nice case, I think, Ed, on the presidential assassin in the abstract, and Jack the Ripper in the abstract. I think that there's a more real case, and that reality is really Paul Brandsburg, and that reality is really a reporter who goes down to a police station, interviews a policeman, and is then made a witness to his own interview with the policeman, and I have just been through that with a reporter from the New York Times, a witness to his own interview with the policeman, some of which was confidential, some of which is not. In totality, it can only interfere with the public getting the kind of information I think it should get. I really don't think that the assassination example, which lawyers incidentally are confronted with in court every time that they argue these cases.
Was this the prosecution or the defense seeking this? Was this the prosecution?
In that case, it was the defense.
Yeah. It often is. And if I were the defendant, I wouldn't feel so horrified about, in this instance, maybe not giving the newsman as much leeway as he would like. It's a very hard case when you're talking about sending a man to jail or not.
Yeah, but that doesn't put any First Amendment input on the scale at all. Sure, it's a hard case. There are a lot of hard cases, and the fact that it's a defendant, in fact, does impress me more than the fact that it's law enforcement. But to say that, it doesn't seem to me answers it.
No, it doesn't answer it, and I concede that a court should examine each case in which a subpoena is sought and say, is this really necessary to the case? Is it being done for the purpose of harassment, and so forth and so on? But that is something quite different from laying out either a categorical shield law or even a qualified law that gives an absolute privilege in certain defined cases, which I find it very difficult to define.
Do you think, Mr. Abrams, that there is a right to know on the part of the public?
Let me say that's a phrase that troubles me, because if there's a right to know, then I suppose the public has a right to compel the press to print things, or the judiciary may have the right, or someone may have the right to decide what it is the public should know. I think that the First Amendment ultimately serves the public by letting it learn things, letting it hear things on television, letting it see things that it wouldn't otherwise know. There was a case out in Indiana last year involving ABC, in which they were barred by a prior restraint, an injunction by a court, for over 200 days from doing a show demonstrating, proving that plastic cribs burned more quickly than wooden cribs. I think the public had a right to know precisely what ABC wanted to tell them, and that it was a most offensive interference with the public's right and the press's right for the courts to intervene in that area and to interject an injunction which prevented the public from knowing what was going on.
What about the case of the producer of hashish and the impact that production might have not only on the public but the children of people watching that television program? Does the society have some very strong interest in revealing who it is that is producing that and likely to introduce it into the
That was not the thrust of that particular program, though, was it?
In the Brandsburg case, the thrust of it was how easy it was to make hashish in Louisville.
Yeah, it was not to show people how to do it or to encourage
somebody
the use of it.
somebody doing it, though, who would then presumably distribute it in the community.
That's right. But the point of it, though, was not to promote the use of it, but to discourage it. That was the point of the program, was it not?
Yeah. I mean,
I have the same. You know, that's back to my Patty Hearst case. I don't like that kind of a show because it again is telling the society, look what you can do. You can go in and take a picture of this thing. And somebody says, why don't the cops get those guys? They're making up this dope, and you know it's going to go out on the streets. But no, we can't do anything.
I know you don't like that kind of show.
It has to corrode the whole attitude of the society towards whether it is really opposed to crime.
But I really think that the Department of Justice or the courts should refrain very strongly from imposing what they don't like, which is what you're talking about, into law. It may be, and indeed it is true. A lot of things the press prints are harmful. They're destructive. They hurt people. I think we've made a decision in the First Amendment to run that risk and not to run the risk of having government officials make those decisions.
How great should that risk be? We might move into the issue of libel laws. How is there any right that should accrue to a private citizen to sue the press if they step over certain bounds in accusing them of
well, they have that
wrong?
Right, don't they?
Yes,
they have the right.
Yes, they do. I wonder whether you agree that they should, under your theory of absolute.
Under my theory of absolute privilege, I'm not so sure that I'm too much in favor of libel laws, I have to admit, but they do have the right. Unfortunately, they do have the right. I'm in favor, almost in favor of absolute, complete press freedom, whatever that means.
Then it raises the issue of whether the public would get truth or falsity, because even if the reporters had the right to publish anything and to conceal their sources so they could concoct any deep source they wanted, it's not clear that there'd be any way of testing the truth of what they were publishing, or that in the long run newspapers would have any credibility. Strong libel laws.
They're part of the free enterprise system, and they sink or swim eventually on their credibility.
But the newspapers that succeed with the public might succeed because they publish very plausible lies rather than unbelievable truths.
Some of them do.
Right, and that's what you would want to see.
Well, it's not what I want to see. It's what happens in this free market, market of free ideas, and I don't see it as all bad. It's not all good, but it's not all bad.
There's an alternative.
And I think the alternative is government
Well, to have strong libel laws. No, to have strong libel laws.
Well, that's
and to have
regulation.
Just as happens in any book publishing or academic
You're
work.
in favor of stronger libel laws than we now have?
Oh, the libel
Are
laws.
you not in favor
the
of
libel laws we now have are a joke when it applies to a public figure.
Well,
it's almost impossible for a public figure to successfully sue, and it's very convenient for me as a journalist. I mean, it makes things very easy, but I think that what's going to happen in the long run is the press is going to lose its credibility because so many things will be published that no one will know what to believe.
Well, Mr. Seib is part of the effort to help us restore that credibility by being the ombudsman for the Washington Post.
What is an ombudsman, Mr. Seib?
Good question.
Tell us. I think it is a growing trend.
It's a growing trend. The press trying to police itself. I don't know if it's going to work or not. I've been in this job 8 months now, and I'm not sure whether I'm doing good or harm. But the libel, until the press is ready to accept its responsibilities a little better than I think it does generally, I think probably the libel law is at least protecting the rights of the private citizen who doesn't, by running for office or by taking public office, expose himself. I think that's the minimum we should have right now. I can't quite see that the press is ready to remove all restraints and rely totally on the marketplace and the ultimate triumph of good over evil to solve the problem. The area I'm concerned with is fairness and accuracy and balance. That doesn't really come under the libel laws. The libel law is sort of the last resort for as you say, the public figure really doesn't have much access to them anymore.
Well, you're the access.
I'm the access now to the extent that a corrective piece or a discussion piece ever catches up with the original error.
Let me try to get back to that toward the end, Mr. Seib, because I think it's important what might be done by the press itself to ensure responsibility. Do you see any other restrictions, for instance, in the name of national security, on the right of the press to print material that comes into their hands?
I don't. I'm sure you could concoct a case where national security or the security of certain individuals required restraint in publishing a story, at least for a short time. But generally speaking, the claims to national security, I think, should be very harshly examined by the editors, by the press. My position is that the press does have absolute privilege under the First Amendment, that editors
Absolute privilege to do what?
To report whatever it gets a hold of.
That the courts, in other words, have no role in trying to restrict
the press in printing, even if it were to involve what by a reasonable man's definition would be a grossly irresponsible act, may even jeopardize the lives of some people, still the courts would have no right to move in.
Well, that's hard to say. I mean, philosophically, I believe that. Because I believe that
the press... in practice?
In practice, I think, first of all, I think they would move in. I don't think, I think it's kind of a...
Look, it's not very hard to get the press not to run a story.
That's right. It's too easy, as a matter of fact.
Yeah, it's very easy to get the press not to run a story. William Colby went around and got the Los Angeles Times and the New York Times and the Washington Post and Newsweek and Time and NBC and CBS and ABC and Public Broadcasting and I don't know who else not to run the Glomar Explorer story on grounds of national security. Now, the story ran and nobody's been able to tell anyone where national security was really involved in it.
And the picture of this official running around town trying to stop this thing, dribbling little bits of information as he went, because in each conversation he, in order to convince the parties not to publish, he gave them a little more information. It was really ridiculous.
But you think that a public interest was served? Actually, I read the story in the Los Angeles Times. Didn't they publish the story before the Times 2 weeks before?
They had the wrong ocean.
Well, that was before. that was before Mr. Colby had.
Right. So the story was already published. But aside from that, I don't see the public interest that was served by publishing that the CIA was perfectly legitimately retrieving a Russian submarine from international waters.
Well, let me.
And it's the only legitimate operation I've ever heard of that the CIA has done.
All right. Let me ask you something. Yeah. Here was a ship out in the middle of the ocean, operated by Howard Hughes, who's always been.
It wasn't operated.
Well, all right. It was owned by Howard Hughes. Mm-hmm. It was a Howard Hughes operation. It was a Howard Hughes CIA operation. Sure, it was. The CIA itself
was a CIA operation.
Involving $250 million of the public's money.
In any event, you see nothing wrong with a private contractor out on the sea recovering a Russian submarine, and with the involvement of Howard Hughes, who's always been on sort of the fringes of shady government operations. You see nothing wrong with that, and you don't think the American people are entitled to know about it?
Wait a moment. The retrieval of the submarine was done by Howard Hughes built the ship, but then it was taken over by another company, Glomar.
Yeah, which is also a Howard Hughes operation.
Well, in any case, I think it was...
Listen, I'll say no to his question if nobody else will say no. I don't see anything wrong with it. I think it was a great job if indeed it happened the way they said.
Well,
and
why
not publish it?
Is that the key to whether
the reason not to publish it is very clear, is it stopped them from retrieving the rest of the submarine. That's the reason not to publish it. And it
that's what they said.
Destroyed the expenditure.
Do you think that the Russians didn't know that this ship was out there? I mean, the CIA said they assumed.
But this is the key issue. Who is to be the arbiter of what the
press?
You want the press to be the arbiter of whether something is of interest to national security, whether the press would somehow know what the Russians knew and what the Russians didn't know. I don't want to be the arbiter of what...
The same national security argument was used to cover up Watergate, to cover up the Ellsberg burglary. All of the things that came out after Watergate. National security was stamped on almost every one of them.
Of course. In other words, you want to be the arbiter of whether some operation is national security or not. Let's just get this very clear.
Let's face it. Yeah,
and you feel that by your education and your knowledge of the world that you are
not just me, the press generally.
Well, I just can't take that.
Who do you want to be the alternative, Mr. Epstein? The alternative is allowing the Department of Justice and the court system, that other branch of government, to make those same decisions as to what the press can print. And I think that has very considerable risks, which were well recognized in the First Amendment itself. The Pentagon Papers, of course, is a good example of that. God knows we heard enough about national security in that case, about documents which were historical in nature.
And it was another case, but it was another case of where the press cooperated with the government.
Wasn't the New York...
And did not run them.
Who do you mean by the press? I asked before, who was a newsman? You're talking about the press cooperating. We get the picture of everybody with,
Well, the New York Times didn't run the Pentagon Papers until it was authorized by the court.
Some cases...
The Times didn't violate the court order. Yes.
Some cases that have come before the court have involved reporters from an SDS underground newspaper, do these people have any less claim to being reporters?
No.
All right, then you say it's one thing if a spy gets information and disseminates it, but it's quite something else if he's working on the staff of the Daily Worker. Is Is that the distinction you draw?
Well, if it's the Daily Worker, it may be espionage, and if it's espionage, it should be liable to criminal prosecution. But if it's news gathering, yes, I think there is a distinction. I don't think it's a hard distinction.
I don't want to be on the other side in court, having to demonstrate that distinction.
Well, I would hope that you would recognize that distinction between the Daily Worker and other newspapers which gather news for the purpose of reporting news to the public.
Well, you surely can't distinguish between one newspaper and another. You have to establish some principle as to how it's acquired or
Well, look, you know if a reporter for the Daily Worker is involved in espionage work, the results of that are not going to show up in the Daily Worker.
You have to assume that to have a free press, and I'm convinced that the system wouldn't work without it, there's a price. Now, perhaps it would have been better. The CIA might have been able to go back and gotten the code machine, if such there exists, if we hadn't printed the Glomar story. But that was a price for a free society.
But what did we gain for that price? Other than one day.
Well, I buy this.
I don't know that we lost anything. I don't
know we lost anything either.
You see, we don't even know that we got anything. All we know is what the CIA told us, and that's all.
Jack,
and we do know they don't always tell us the truth.
But that's my problem. I have no way of knowing what a code machine is, no less how it would be valuable to figuring out some Soviet codes or not figuring them out. I agree with you. I'm absolutely ignorant in this field, but then how can we be the arbiters of whether something is legitimate national security or not? That's the dilemma as I see it, that someone has to...
The answer to that is that maybe the press ought to, given a credible government, sometimes believe it.
Yes.
And I mean, I have no objection to Mr. Colby going around Washington trying to persuade people.
Obviously,
I just
a lot
think
of
the press
editors
ought to make the decision about whether to believe him.
Obviously, a lot of editors did believe him because they didn't run the story until finally Jack Anderson broke it on radio one night. So obviously, a lot of editors and a lot of television news executives did believe Mr. Colby.
Well, I think this analysis of the Glomar thing is, as to the possible harm it could have done, is really not as profound as it ought to be. What action the Russians can take, if they already know it, may be quite different from what actions the Russians can take and feel obliged to take if they already know it and the whole world knows that they know it.
It's obvious that freedom of the press means different things to different people. Sometimes even the courts have trouble interpreting this basic constitutional protection, especially when there's a conflict among the people's right to know, protection of individual rights, and the safety of the republic. Now, to challenge our speakers on freedom of the press, let's go to our experts in the audience.
Without any more introduction than that, I would like to call on somebody from the audience who might have a question. Yes, sir.
I'm Howard Pennyman from Georgetown University. Back in June, the Los Angeles Times printed a story by George MacArthur about the heavy bombing of South Vietnam on the last days of the war. And then Mr. Seib wrote an excellent commentary on it a little later. And then last week on the 25th, the Los Angeles Times wrote a retraction of it. Indeed, George MacArthur himself wrote the retraction. And the Post on the following day printed a note on the retraction. The Post, in printing the note, said that it was clear that the White House and the Pentagon did not have any responsibility for any significant bombing. What the Post did not include was included in the Los Angeles Times, which was that all the effort made by the reporter in Washington could find no evidence of any significant bombing. In fact, to have been ordered by anyone. Furthermore, which leaves still some questions. One, how far did the Los Angeles Times, or should the Los Angeles Times, go in protecting something which you more or less laughingly referred to as American reputation or American face, and that is involved in this? Is it enough to simply absolve the president? Is it enough to simply say that, yes, we have now said there was not significant bombing, which still leaves implied that there was some kind of bombing, a fact which is not yet demonstrated. All of this from one of these wonderful sources which we are to protect. I'd be glad to hear Mr. Scalia on anything about whether he believes this is adequate, their protection of national security, whether their judgments appear to be good, or either of the others on what is a defense of such action?
I don't want to answer it, I guess, for the reason that I really sort of jump off the boat as far as the proper role of government is concerned when it comes to correcting the news media, being sure that what they're reporting accurately and correctly. That's none of my business. I don't think it's any of the government's business. That's something quite different. What we were talking about earlier was just a simple question of, can the government obtain information it needs that is necessary for the administration of justice, and can the government, in some situations at least, prevent the dissemination of information that would be detrimental to vital national interests? Those two questions are quite different from the problem of, if you want to call it, irresponsibility of the press. I think we've made a decision under the First Amendment that they can be as irresponsible in what they choose to say as they wish, and that the corrective is the voices of those that are responsible and can correct them, and to some extent the libel laws, I suppose.
Well, I would agree with Mr. Scalia that it's not something for the government to take any action on, or anyone else other than the newspaper itself. Now, the government did take action in that the government not only denied it, but pursued its denial. As a matter of fact, I happened to run into Ron Nelson, the President's press secretary, at a bar in the evening before the retraction came out. It was not just the day before, but sometime before. And Nelson told me at the time, he said, you had this story, and he said, we called in and we told the Los Angeles Times that the White House unequivocally denied that the bombing had taken place. And he said, yet you ran the story, and down in the story you ran the denial parenthetically. He said, we think that's wrong. And I said, well, I don't know any more about it than what you've just told me and what I've seen in the paper. And if we don't have more to substantiate it than that, I think you're right. I think it is wrong. And he said he was going to write to the editor, which I'm sure he did. Now, Charles Seib did write an editorial column on it as the ombudsman for the Washington Post, in which he said the LA Times had never been able to substantiate its original story. Bill Thomas, the editor of the paper, took it very seriously. He looked into it. George MacArthur, who wrote the story and was in our Saigon bureau, came back to the United States. He spent 2 or 3 weeks trying to prove whether the information was wrong or whether it had been right, and the government denial was wrong. He could never really get any substantiation for it, and he admitted it, and he wrote the story. But I think the point is, and Bill Thomas said this in the article that MacArthur wrote, Bill Thomas said that the Los Angeles Times was wrong. It should not have run the story because it got an unequivocal denial, that it should have gone back to MacArthur, and this is not really an excuse, but it's what happened. The communication never got back to MacArthur that there was an absolute unequivocal denial, and the story ran with the denial. Bill Thomas says the paper should have never run it. We ran a page 1 correction, as Charles Seib said, probably the longest retraction in the history of journalism. The Washington Post ran it on page 1, and the New York Times picked it up and ran it, and I think we should have run it. I don't know what else you can do beyond that, but I think it's a good reflection of what newspapers are addressing themselves to now in a matter of responsibility on these things. We've got an ombudsman now, for example, or at least a media critic by the name of David Shaw. He does the same sort of criticism, in a sense, that Charles Seib does, and frequently writes a story that we run on page 1, and he has criticized the Los Angeles Times as well as other parts of the news media when he's found that they've been in error. But I don't know what else we can do on it other than correct it. I mean, you can't, I suppose if a man got too far out and was involved in the story, he might run the risk of his job. I'm sure that whoever was on the desk and who didn't get the message back to MacArthur or something, he's probably heard from the editor about it. I don't know what else you can do, though.
Mr. Seib.
I'd like to comment on that because I think that whole episode raises a couple of points that go far beyond the story. First of all, one of the main reasons I wrote the column was not because I knew whether the story was right or wrong, because I didn't at that time, but I had a feeling that neither the Post nor the Times was ever going to tell us whether it was right or wrong. I think the press has been very reluctant to clean up its own messes, and both the Post and the Times led with that story that Sunday morning, and making a charge, sticking a couple of parenthetical denials in it, and I knew that it was going to just die there unless somebody gave them a push.
Well, you say you don't know what the press could do about publishing something that might be a falsehood. And I think there's a very simple thing the press could do, and it doesn't involve the government at all. The journalist could simply publish his source. In this case, if the MacArthur had published who had told him that the United States had bombed Vietnam on that day, that source would be quickly discredited. Let me give you an example. There was a charge made that Alex Butterfield was a CIA agent in the White House. The New York Times, to its credit, if it didn't name its source, it intimated so strongly that its source was this man, Fletcher Prouty, was that his name?
Yeah.
That very quickly people zeroed in on him, and it became clear that he named his source then as E. Howard Hunt, and very quickly E. Howard Hunt then denied that he knew anything at all about Butterfield, and Butterfield was cleared without a major calamity.
George MacArthur would have no sources if he identified who his source was.
Well, but is it better that the public have the truth? Who's the client of newspapers? Is it the public or is it the source? If you're trying to protect the source or the reporter, sure, it's better for the reporter if he never names his source. But what about the 10 million readers of the Los Angeles Times who read that
they now know the story was wrong? What
no, they don't. They might not. They might not have read the same people who read the paper on one day, might not have read it on another day. Also, the Los Angeles Times denial wasn't unequivocal. It said that no significant bombing we were able to establish. It becomes much more confusing.
Let me ask Mr. Nelson, what effect you indicate that this responsibility to act responsibly should primarily be left to the press and not exclusively left to the press. What effect do you think the competition for news has on the exercise of this responsibility?
Well, I think it has a tremendous effect, and not only that, I think the whole diversification of the media has a tremendous effect. I mean, if we go
positive or negative?
Well, it's positive. I don't think there's any question about that. I mean, if we go way out on the limb on something, as we did on the Vietnam bombing, you know, we're going to get called short on it. You've got all of the news magazines, you've got the networks, you've got the large newspapers, you've got all the wire services, AP, UP, the supplemental news services, and if you really make a substantial error on a matter of some importance, you're going to be, the public is going to know about it, and it's going to know about it beyond Mr. Seib's work, because other publications will find out about it. And you can't retain your credit.
How often do other publications point out the errors made by...
On matters of substance, I think they do it frequently. They may not say that this was an error, but they print the story as it really happened, which, you know.
To what extent do you think the competition that occurs forces you to come out with stories before you're able to completely verify their accuracy?
Well, I think it happens sometimes, and I think it's regrettable. I don't think it happens very often. I mean, I can remember a few very bad examples. I can remember, for example, the Eagleton matter involving Jack Anderson, which I thought was bad, and which he later admitted was bad. But how many instances can you think of on a really major matter where a newspaper or radio or television came out with something of real importance that was wrong because they were trying to be first? When they do it, it's inexcusable. Sure.
The Agnew case involving the Vice President of the United States, the competition among the press was fierce in that case. They were all over the Justice Department halls and the U.S. Attorney's Office in Baltimore, plus the Vice President's office himself, trying to get information on an ongoing investigation for which there was no cover-up. Many of the stories that
all of it happening, however, in the aftermath of Watergate.
Yeah, I'm not saying it wasn't understandable. That doesn't make it justifiable.
It doesn't. I agree with you.
And many of the stories that were published were full of inaccuracies.
Don't you think the Butterfield Prouty incident was based on might have not happened if the NBC and CBS hadn't been so competitive?
Yeah, I think it's possible. And I say, you know, there are cases, but I don't think there are that many major cases where you find this. And when it does happen, it's absolutely inexcusable. I don't think there's any way to say that newspapers or television are right ever when they try to be first and they're wrong. And I don't think that's the trend either. I think the trend is in the opposite direction. I know it's the trend, for example, on the Los Angeles Times, and has been for a long time. We've been told, for example, in the Washington Bureau, look, and I've had particular cases where I would be on a story and say, the New York Times is here, the Washington Post is here, and this was in the past few years. And the editor on the end would just hold on, don't get the story now, get it, be sure you get it all, be sure it's absolutely right, we don't care if they're first. Now everybody wants to be first. You know,
There's no question about that. But I don't think that's the trend in journalism in this country. I think the trend is to be right, not first.
Don't get it right, get it written is no longer screamed in the city rooms.
I think that's right.
Mr. Ruckleshaus is not suggesting, I take it, that we'd be better off if we had only one newspaper.
No, I'm not, but I think that it often is missed on the part of the public that the competition for news, particularly here in Washington, is very strong, and that this competition itself has a way of creating its own momentum for a story to be published before there is adequate opportunity to verify it. And having been involved in the middle of this Agnew investigation, I thought that was a prime example of where the New York Times would editorialize about the Justice Department leaking information which we were unable to find, and the newspaper, as though this was awful, why don't they protect this poor man's rights? And then they unleash a horde of reporters in that same department trying to get the information. There's a certain Olympian...
Wasn't that the Washington Post?
No, that was the New York Times.
Don't you agree, though, that there have been unusual times in Washington in the past few years because of Watergate and the fact that the resistance of government to give out information of legitimate public interest, information that should have been given out. It took 18 months to find out who was on the White House payroll during the Nixon administration. I mean, just matters you could go down to any city hall. That's right.
I think our time is up.
Yes, I think that we are running out of time, and again, in closing, I would like to indicate my appreciation and that of the panel for the audience's participation, and recognize that while we've all joined here together, and by no means will we leave in complete agreement, one of the principles that has been stood up for here with such great articulation by the defenders of the press, I believe is precisely the reason we're able to meet like this as free men and women and discuss as freely as possible and with little chance of any interference issues as important as freedom of the press and the future of this society. So again, on behalf of the panel, let me thank all of you for your participation and thank the members of the panel for being here.
This roundtable discussion has brought you the ideas of 5 experts who have differing views on the many interpretations of freedom of the press. It's the aim of the American Enterprise Institute to illuminate issues of the day by presenting many such views, in the hope that by so doing, those in positions of decision-making will benefit from such a free exchange of informed and enlightened opinion. I'm Peter Hackus in Washington.
Public Policy Forums is created and supplied to this station as a public service by the American Enterprise Institute, Washington, D.C.